I'm Professor Michelle Foster. I'm the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to the fourth Oration in the Ninian Stephen Law Program lecture series. I'd like to begin this evening by acknowledging that we're gathering this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging, and extend that respect to all Indigenous people who are joining us this evening. I'd also like to acknowledge that today is an historic one because in the Victorian Parliament today we saw the introduction of a statewide treaty bill. So certainly an historic day to be meeting. Well, this oration forms an important component of the Ninian Stephen Law Program, New Legal Thinking for Emerging Technologies. This collaborative program is run by the University of Melbourne's Centre for Artificial Intelligence and Digital Ethics and generously supported by the Menzies Leadership Foundation. Through a program of research, dissemination and engagement, it aims to build capacity in the legal profession in responding to the challenges of rapid socio-technical change now and into the future. I'd like to thank my colleague and Centre Director, Professor Jeannie Patterson, for her outstanding leadership in this critical sphere, and as well as the entire New Legal Thinking for Emerging Technologies team, many of whom are joining us this evening. Well, the Australian judiciary is at the forefront of technological change impacting the legal profession. And of course, AI is at the heart of these challenges. Chief Justice Stephen Gageler of the High Court of Australia recently described the presence of AI in the courtroom as an existential challenge, although adding that AI functions within legal processes were not necessarily all negative. Chief Justice Andrew Bell of the New South Wales Supreme Court has echoed these sentiments, recently referring to the increased scope of mischief of increasingly sophisticated technologies that are challenging both the profession within the courtroom and policymakers who are attempting to regulate these technologies. And so it's a pleasure and a privilege to introduce tonight our own Chief Justice of the Supreme Court of Victoria, Justice Richard Niall, who's going to deliver tonight's oration. Chief Justice Niall was appointed Chief Justice of the Supreme Court of Victoria in 2024. Prior to this, he served as a Judge of Appeal at the Supreme Court, presiding over criminal and civil appeals. He joined the Victorian Bar in 1995 and in 2010 was appointed Queen's Counsel, then serving as Victoria's Solicitor General from 2015. He's the 13th Chief Justice of Victoria. Recently, in public comments, the Chief Justice pointed to the profound challenges that AI presents for the integrity of the judicial process as the legal profession innovates with more automated processes and research techniques. He highlighted a desire for national consistency and standards as AI becomes more entrenched in law. So as the fourth Ninian Stephen orator, the Chief Justice is ideally placed to address this gathering this evening on the themes relevant to the New Legal Thinking for Emerging Technologies project. Thank you very much, Chief Justice, for being with us this evening. Before I call him to the podium, I will just mention that we will have time for questions at the end of the address, and they will be ably moderated by my colleague, Professor Jeannie Patterson, after which the eminent Peter Jopling, AMKC, as Chair of the Menzies Leadership Foundation, will offer some closing remarks. But now, please join with me in welcoming Chief Justice Richard Niall.
Thank you very much, Professor Foster, for that very kind introduction. Can I echo the acknowledgement that we meet on the traditional lands of the Wurundjeri people and pay my respects to Elders past and present and all First Nations people who join with us tonight. I'm also pleased that members of Sir Ninian's family, Sarah Stephen, the Honourable Chris Maxwell and their daughter Alex are also present tonight. May I also acknowledge Peter Jopling, AMKC, Chair of the Menzies Foundation and Board Member Mr Harvey Kalman, and I am delighted to be able to deliver this address as part of the Sir Ninian Stephen Law Program. Thank you for your attendance. It's a real pleasure as Chief Justice of the Supreme Court of Victoria to give an oration in honour of one of the members of my court. Sir Ninian's distinguished career of public service traversed law and diplomacy on a global scale of a singular kind. He began his career at the Victorian Bar, made Queen's Counsel in 1966 and was appointed as a Judge of the Supreme Court in 1970 before joining the High Court in 1972. Sir Ninian went on to serve as the 20th Governor-General of Australia, and from 1982 to 1989, and in the years that followed he was Australia's first ambassador for the environment and was a highly esteemed international judge and mediator. The focus of this year's program, named in his honour, is the law and emerging technologies. In 1982, the year Sir Ninian retired from the High Court, Time magazine departed from its tradition of naming a man of the year and instead named a machine of the year, the personal computer. The following year, 1983, is often cited as the advent of the modern internet, and the depth and pace of advances in technology since that time is breathtaking. This evening I wanted to explore artificial intelligence in the judicial process. Artificial intelligence, or AI, is a broad concept that encompasses many ways in which machine-based systems collate, synthesise, catalogue and generate information. AI systems vary in their autonomy and adaptiveness after deployment, and was first used as early as the 1950s. The mainstream use of generative AI has soared over the last few years with the advent of publicly available large language models like ChatGPT, and there are now generative AI products tailored to the legal market. It is clear that AI is here. There are a number of ways to demonstrate its emergence and scale. Investment is one metric. In 2015, Alphabet, Amazon, Microsoft and Meta had a combined capital expenditure of around $25 billion. 2022, the year ChatGPT was launched, the figure was $140 billion. And in 2030, it's predicted to exceed $500 billion. So from 2015, 25, 140, 500. The growth has been in data centres housing the new generation of chips to power generative AI. Another indicator, apart from investment, is energy use. The International Energy Agency says electricity usage for data centres is forecast to climb from 415 terawatt hours in 2024 to around 945 terawatt hours by 2030. To put that in some sort of context, the anticipated electricity usage for data centres is roughly equal to the total electricity consumption of Japan, or about 3% of global electricity demand. As computational power grows, electricity consumption increases exponentially. The so-called hyperscalers, who are engaged in the computational arms race, are constructing data centres based on the availability of energy sources and water. The four that I have mentioned have all struck deals with nuclear power generators to power their data centres. Microsoft is reported to be working with Constellation Energy to restart the 3 Mile Island nuclear power plant in Pennsylvania to provide power for its data centres. Presently, water is used to cool the chips, and in 2023, data centres in America consumed about 55 billion litres of water. It might be that Sir Ninian would have been more concerned about the implications of AI from his perspective as Australia's first ambassador for the environment than he would have been as a judge. It is possible that the investment of which I speak will fail. A recent report from MIT made the startling claim that despite $30 to $40 billion of investment in enterprise level, 95% of organisations were getting zero return from Gen AI. But the point to make is that the sheer weight of investment is likely to yield significant changes in the computational power, and the pressure to adopt that power into different sectors, including the law, will be enormous, if not irresistible. The potential role of AI in the judicial context is broad. At one end of the spectrum, AI can be used as a tool to augment the work of a judge and support the decision-making process. And at the other extreme, AI could replace decision-making by judges altogether. As the Australian Institute of Judicial Affairs notes, depending on the purpose of the system and the safeguards thought necessary to be built into it, human oversight can range from human or technology in the loop to full autonomy. In courts and tribunals, we must grapple with how we can harness AI in ways that maximises its potential benefits and minimises the risks. In my view, we should focus our attention on problems that can be ameliorated or solved with the use of AI. The fact that AI can do something does not necessarily mean that it can do it well or that it can replicate the judicial process. And even if it can do so now, at some point in the future, we have a responsibility to interrogate what tasks and functions it is appropriate to delegate to AI and to what extent we should do so. I am mindful that a lack of understanding and fear about new technology poses risks in terms of missing out on the potential benefits that AI presents. Victorian courts and tribunals have a culture of embracing digital innovation and have adopted new technology to great effect. For example, our e-filing systems, our transition to online hearings in response to COVID-19 provide two examples of swift and detailed embracing of the digital innovation. I'm confident that AI will be no different. At present, there is a trial being conducted in the Coroner's Court about the use of AI, and initial scoping work will shortly commence in the Supreme Court to trial the use of AI. I am cautiously optimistic about the potential benefits of AI and the ability of our courts and tribunals to explore and harness the technology in thoughtful and appropriate ways. As the Dean has remarked, Chief Justice Gageler has recently referred to the rise of AI as posing an existential threat to the judiciary. By that, I take his honour to mean that it ought cause us to reflect on the existence of the judicial system itself, its attributes, characteristics and purposes, and reflect on how the system might interact with or coexist with AI. It suggests that AI, the emergence of AI, is not just another tool of technology that can be used, but one which might reshape how courts operate and the nature of judicial determination itself. In order to explore this existential threat that His Honour identified, I want to make some brief observations about the judicial method in order to frame the discussion. Although we often want to talk about the capacity or what AI involves, the starting point, I think, should be on the judicial system itself and what it offers. It is only once we have in mind the way the judicial system works, identifying its strengths and weaknesses, that we can understand how AI might be usefully employed, where it might add value and where it might undermine the system's very existence. So let me turn to what judges do. The most important thing that judges do is to make orders. Orders embody the judicial determination of a legal controversy and govern the rights and duties of the parties affected. The effect of orders is to change an uncertain and contentious claim into a settled outcome. Orders provide authority for the executive to act, including in the most profound way, such as incarceration or the eviction from property. Orders are the end point of the judicial process. If we want orders to be made quickly and without prevarication, then AI will be a boon. But the ability to secure compliance with orders by force of the executive if necessary remains the critical touchstone of the rule of law. And in turn, compliance depends on there being a sufficient well of respect for the judicial process. One cannot divorce the validity of the order and the acceptance that it garners from the process by which it is made. The question I wanted to explore tonight is whether there is any role for AI, especially generative AI, in the process that leads to the making of those orders. I want to touch on some aspects of the judicial process: fact-finding, the exercise of discretion, and the giving of reasons, all three essential attributes of the judicial process as we understand it today. But these aspects, fact-finding, the exercise of discretion and the giving of reasons, can't be divorced from and are bound by some fundamental conceptions. First, we operate in a common law system. That system contains both a body of rules and legal principles, but also a method. Whether or not described as a strict and complete legalism, it has a discipline that focuses on the case at hand and the strict application of principle, but which is capable of evolving to capture new perspectives or reflect changing times. Importantly, it is not an inquisitorial system in which a court sets the boundary of inquiry, but involves the adjudication of practical disputes tendered by the parties for the court's determination. Second, the power and authority of a court is conditioned by an obligation to accord procedural fairness, often described by reference to the two pillars that require an impartial mind free of any taint of bias and an obligation to provide a reasonable opportunity for an affected party to be heard before a decision is made. The third aspect is that the power is exercised in public. Open, transparent justice is a critical aspect of our judicial system. In Russell and Russell, Justice Stephen noted that a tribunal which of course conducts its hearings in closed court is not of the same character as one which habitually conducts the proceedings in open court. When one looks at the judicial system, there is much to be proud of. It involves the fair and independent determination of disputes by application of settled legal principle by an expert and well-trained judiciary with those three attributes that I've identified. If it were perfect or could not be improved, then there would be no case for AI intervention. But nobody thinks the system is perfect. When considering the potential for AI in our judicial system, we should focus our attention on the problems that AI might address, the so-called use case. The most common criticism of the judicial system is that it is slow, accessible, and not accessible to many in the community. These are significant and enduring criticisms. Delay is a significant burden on litigants and the community. It is a symptom of the volume of cases initiated, their complexity, and the level of judicial resources available to hear and determine them. Judging is time-consuming. Costs are often both high in absolute terms and may seem disproportionate to the value of the claim. There are also concerns about decisions that are made. Concerns are expressed about consistency and whether decisions are explained in a way that can be comprehended by those in the community. Within the judiciary itself, some judicial officers feel overburdened. There is the burden of the number and complexity of cases they have to deal with. In the criminal context, the sheer volume and speed of legislative change may be difficult to keep up with. In the civil context, technology has vastly increased the number of documents that may be produced, and court books running into thousands of pages are not uncommon. Both the legal and factual material that judges have to master in a given case are often significant, and judgment writing takes an enormous amount of time. We are also increasingly understanding of the risk of vicarious trauma that can be associated with viewing or reading about highly traumatic events. This is the potential problem not only for judicial officers, but also their staff. Is there a role for AI to address these issues, to speed up judicial decision-making, to reduce cost and increase access to justice? Our legal system is one of individualised justice in which each case is considered on its merits. This takes time. There is no doubt that AI could be employed to significantly decrease delays and to increase efficiency, gauged by number and time of dispute resolution. But in what circumstances is this appropriate and at what cost? And now I wanted to talk to those areas about fact-finding, discretion, and judgment writing. In considering the potential use of AI in our courts and tribunals, it is understandable that there will be discussion about its accuracy and capability. The courts already have had experience of receiving documents generated by AI that are inaccurate, misleading, and which contain fictitious references. It is likely that this capability issue will be addressed both by a change in practice, including a recognition of the responsibility that exists on every party that relies on the contents of a document in court to ensure its accuracy, and through the evolution of AI accuracy itself. I see these problems of hallucinations, of misleading and inaccurate information as not being existential. They're practical, and it is unlikely that they provide a sufficient reason to resist entirely AI on the march. The issue about the use of generative AI in the judicial processes are more fundamental. They go to the extent to which the adoption of AI in judicial decision-making would threaten transparency and judicial independence if underlying algorithms are confidential and impenetrable, limiting understanding and critique of the decision-making process. While AI has the capacity to increase access to justice, it also raises the issue of equity, which must not be overlooked. Within that context, can I then turn to fact-finding, the exercise of discretion and the giving of reasons? Litigation is always backward-looking. What happened in the past, as a matter of fact, is the most important issue in the overwhelming majority of cases. Once the facts are known, the application of legal principles will often follow without too much controversy. And it is the uncertainty of where the facts will land that encourages settlement of cases. In those cases where the facts are to be found by a court, the process involves the parties selecting the evidence they wish to adduce, the calling of witnesses in open court, and the tendering of documents. In some cases, it will be the oral evidence of witnesses that will prove most important, and in others, it will be the documents. Experience shows that it is now rare that a witness's oral account is not tested and challenged against some documentary record. There seems little doubt that AI will significantly affect the availability of evidence and the process by which evidence is located, collated, synthesised and adduced by the parties. The digital footprint has grown, and with the development of AI and vastly increased computing power, the amount of data will grow exponentially. Vast digital databases recording the details of our lives are not the sole province of the dystopian authoritarian regime. This will inevitably lead to an increase in the amount of material that is available for the purpose of any litigation. Emails, correspondence, file notes, purchase orders, contracts, and other related documents will increasingly have been created, modified, or edited by a large language model. The clinical notes of doctors may be generated by AI from a recording of the consultation and may proffer differential diagnosis or suggest the need for pathology or radiology testing. Expert evidence, which covers the full gamut of fields of expert knowledge, will be informed by AI. Where the expert is called upon to conduct analysis, modelling or estimation, it is likely that the various disciplines will have incorporated AI to a greater or lesser extent. Where the claim is for damages, the analysis will often require consideration of the counterfactual. What would have happened had the wrongdoing not occurred? This hypothetical exercise is often the critical element in the calculation of loss. Again, it is inevitable that the modelling required to fashion and consider the myriad potential alternatives will be aided by AI. In this context, where much of the primary evidence and expert evidence will be influenced by AI, there will be the risk that AI will be used illicitly to manufacture evidence, including documents and images. In the context of fact-finding, AI presents serious challenges in relation to the authenticity of evidence and the potential inaccuracy and unreliability of AI-generated information, which litigants and their legal representatives may present in court. These issues were recently explored by Chief Justice Bell of New South Wales. Again, it is likely that these matters can be addressed by vigilance and with technological solutions. The question of authenticity is obviously important for courts, but not uniquely so. Deep fakes will be a feature far beyond the litigation context. And again, I'm confident that there will be means to deal with those. And again, they do not present a sound reason for resisting the use of AI altogether. In preparation for trial, AI may assist the parties in the efficient identification of relevant documents and in ordering and summarising their contents in a way that will assist in case preparation. At trial, it is possible that AI will be used by counsel to summarise a witness's evidence as it is given, identifying points of conflict with other parts of the evidence to aid a challenge or warn the cross-examiner about lurking dangers and what topics to avoid. In this context, where the evidence will have been influenced by AI, by the preparation of the case will be influenced by AI, what then of the judge? Would it be acceptable in a trial for the judge to use AI to assist by preparing a summary of the transcript of the evidence given that day? What about preparing an annotated chronology that the judge might find useful in following the evidence? Can summaries and categorisation, which AI does very well, reduce the need to view or read traumatic material? And when the judge retires to her chambers having reserved judgment, is it acceptable for the judge to use AI to help summarise the evidence, highlight areas of conflict, or even resolve factual disputes? What about in the exercise of judicial discretion, meaning the power the law gives a judge to choose among several lawful alternatives, which must be exercised reasonably? We understand and accept that in exercising discretions, judges will be influenced by their personal experience and perception of the judicial function and may be guided by intuition. However, they must also act from the perspective of the reasonable judge who is governed by society's values and a sense of justice. An example of this exercise of discretion is the sentencing process. Imagine that judges have access to a reliable, secure AI platform which has high-quality sentencing data, including judgments, sentencing principles, sentencing statistics, which can be uploaded and then to which the evidence in the case, the particular facts, can be uploaded. The judge asks AI to recommend a sentence or a sentencing range. The judge interrogates the output, spars with the AI. Why did it recommend that sentence over another? It asks what factors were taken into account and what are the arguments that might be made in favour of the lowest and highest sentence was in that range. That outcome would plainly favour consistency. What, if any, role should AI play in judgment writing? It is undeniable that AI is of orders of magnitude much faster than a human at summarising and synthesising information and could accelerate exponentially the process of judgment writing. There is no one uniform approach to judgment writing, and ways of working vary between judges. However, in my experience, it is conventional for a judge to write the judgment, aided by an associate who is available to conduct legal research when required and proofread the draft. It remains in Australia the fundamental role of the judge to prepare his or her reasons. This approach contrasts with the United States, where it is typical for junior members of chambers, typically law clerks, to draft judgments. Plainly, a judge could direct AI to produce a complete first draft of a judgment for the judge to review. It could identify and apply the relevant sentencing principles, if it was a sentencing case, and prompt solutions, just as the AI medical notes prompt a differential diagnosis for the doctor. Less controversially, AI could be tasked with summarising the facts, the party submissions, and the applicable law. In the meantime, the judge could focus on drafting the sections of the judgment which contain the reasoning and conclusions. Might this enable the judge to focus on what really matters in deciding the case, freed from the burden of setting out matters of context or uncontroversial history? It is plain that in each of the areas of fact-finding, articulating relevant legal principles, identifying the range of potentially open discretionary decisions, and in judgment writing, there is potential for AI to be deployed to reduce the time taken for each step. But is this consistent with the judicial process? There are a number of issues that need to be confronted in answering that question. The first is that it is wrong to treat the phases or tasks that I have identified as discrete aspects that can be managed or treated in isolation of one another. The steps taken by a judge from summarising the evidence to writing reasons for judgment are connected and form part of a single task. As Justice Kitto has observed, the process to be followed must generally be an inquiry concerning the law as it is and the facts as they are, followed by an application of the law as determined to the facts as determined. His Honour plainly has in mind that the process is a single process undertaken by the judge. Making findings of fact from a summary that the judge did not prepare may not be the same thing as making findings of fact based on the evidence. The process of synthesis or summation can affect the emphasis that different parts of the evidence enjoy or diminish the burden of evidence that is not mentioned or developed in the summary. On the other hand, resources such as chronologies, summaries, list of issues are often used to help the judge frame his or her consideration of the evidence. One of the most important steps in understanding the evidence and being in a position to make findings is ordering the material in a logical and comprehensible form. Large language models can index and footnote the summary, enabling the reader to have direct access to the relevant underlying source material. The second point goes to the nature of the judicial task. As already adverted to, it is not inquisitorial. It is sometimes said that it is the party's case. That means that it is for the parties to identify the issues that they choose to litigate. Chief Justice Gageler has observed that a judge is tasked not with the independent pursuit of some ultimate truth, but with arbitration of a contest between parties who assert different versions of the truth. It is not for the judge to wade through the material and try and come to some just answer free from the case presented. The use of AI to review the material, identify or resolve points of conflict, or identify the legal issues that arise might be quick, the result might be correct, but does it represent a significant departure from the proper role of the judge to hear and determine the party's case? The third related point is that judicial fact-finding is not a mathematical exercise based on probability theory. It is well established that the process of weighing up evidence and reaching a conclusion to the requisite standard cannot be reduced to a mathematical formula. The notion that fact-finding, which is not mathematical in nature, would be trusted to AI based on algorithms risks altering the nature of the process. Fact-finding is often highly qualitative. Appeal courts recognise the advantage that a trial judge enjoys in having seen and heard the witnesses and watched the evidence unfold. A review of the documentary record by an appellate court is not the same thing as a trial. AI may well reach a point of sophistication where it could assess the veracity of a witness's oral statement more accurately than a human. However, even assuming that it could, and this capability could be assessed objectively, would we ever feel comfortable assigning it to the task when the stakes are so high? Fact-finding is a delicate exercise undertaken by a judge or jury. In my experience, it is done with extensive care and reflection. In deciding issues at trial, for example, whether a witness is telling the truth, juries are often invited to draw on their life experience and common sense. In my view, fact-finding must remain the responsibility of a human tribunal of fact, regardless of the capability of AI and the efficiencies that could be gained by outsourcing this task. Fourth, the process of judicial decision-making must be transparent. The evidence and the arguments which the parties seek to advance are exposed in open court. Any questions the judge has for the parties are also ventilated in open court. This process allows the parties to deal with concerns that the judge may have and which may arise during the hearing. To what extent should the parties be told about a judge's use of AI? Should this extend to the identification of the product, the prompts that the judge uses, or by providing a copy of any product of that research for the parties to comment on? On the other hand, it is established that a judge does not have to expose his or her thinking process to the parties as the judge reflects on the case before them. Nor does the judge tell the parties what tasks he or she has given the judge's associate. In my experience, it is common for judges to discuss the issues with their associates as part of the process of formulating the judge's own view. This dialogue remains between judge and associate. Should we treat AI use as analogous to an associate or as analogous to the judge seeking external assistance to help decide the case? The fifth matter is that although AI could improve consistency of outcome is often in tension with individualised justice. Sixth, judgment writing itself is a means of accountability. Reasons for judgment further judicial accountability. Using AI to draft a complete judgment would be an abdication of that duty, and one that does not account for the cognitive process of human decision-making. For many judges, putting fingers to the keyboard and drafting those early sections of a judgment is part of the process through which the case is digested and the reasoning is formulated. In this sense, the decision-making process is iterative, not linear, and the process of deciding a case and articulating the reasons for it are often inextricably linked. A judgment informs the parties of the reasons for the court's decision, which facilitates trust and confidence in the legal system. Sir Harry Gibbs, former Chief Justice of the High Court, observed that reasons are useful to a critical, if not sceptical, audience, who should be convinced that justice has been done, or at least that an honest, careful and conscientious effort has been made to do justice in any particular case, and the delivery of reasons is part of the process which has that end in view. Reasons also equip an appeal court with the information required to determine whether the trial judge has made an error. As precedent, they also play a vital role in the development of the law. Judgments are the tip of the iceberg in the judicial system, and the operation of the law more generally. They occur in a fraction of cases brought in the courts. They operate beyond the individual resolution of rights in that case to inform legal advice and legal adherence to principle. AI tools are trained on existing material, and we are seeing significant demand for judgments as source material to train AI. We value the body of evolving court precedents as an enabler of broader decision-making. I suggest there is a use case for retaining the production of human wisdom, both for its own sake, but also as the basis from which AI external users can draw. Within this context, there are strong reasons to be cautious about the use of generative AI in the judicial process. Judges are humans, and judicial decision-making is subject to human frailty. Many of the problems of delay and expense are a product of the fact that it is a very intensive process. Could AI increase the quality and/or consistency of decisions made? And is this a problem that needs to be solved? In my view, there is inherent value in human judges making decisions. Fundamentally, courts are human institutions. Sir Ninian observed that courts necessarily reflect community values and beliefs, and they do that through the judges that are appointed. Sir Gerard Brennan, former Chief Justice of the High Court, observed that in presiding over a criminal trial, a judge needs to ensure that no one in the courtroom feels humiliated or has their dignity diminished. Values such as mercy cannot be quantified. In the context of machine making decisions, it is also relevant to note Section 24 of the Victorian Charter of Human Rights and Responsibilities Act, which provides, and I quote, "A person charged with a criminal offence or a party to a civil proceeding has the right to have the charge or proceeding decided by a competent, independent and impartial court or tribunal after a fair and public hearing." If AI makes a decision or even assists a human to make a decision, can it be said that the charge or proceeding was decided by a competent, independent and impartial court or tribunal? The Honourable Sir Geoffrey Voss has suggested in the context of Article 6 of the European Convention of Human Rights that machines cannot properly be regarded as an independent and impartial tribunal because they are a function of their training and cannot have human emotions. Based on current capability, it is an open question whether AI can be classified as a competent, independent and impartial court or tribunal in the context of the Victorian Charter. A key underlying reason is that the very nature of AI is mathematical, stochastic, and predictive. It reverts to the mean or the average. While it seems to be generating or creating new information, it is a derivation of the data that has been fed or that it has been fed or trained on, and the ability to consider the unique nature of the individual case is a fundamental aspect of the judge's role, which AI cannot currently replicate. The nature of the judicial decision-making can be distinguished from many other areas of human inquiry that can be enhanced by AI. In areas such as meteorological forecasting or radiology, AI has the edge on the human brain when it comes to analysing big data and identifying patterns and trends. Judicial decision-making differs from many other areas in this respect. It's not just the complexity of the task. Judges make finely tuned, highly considered and qualitative assessments of individual cases, nor is it just concerned with the significance of the decision judges make. Getting a diagnosis of treatment from an oncologist is a significant decision, and I think most people would be comfortable by the fact that it would be aided by the assistance of modelling produced by AI. But I consider that the human brain is capable of absorbing and analysing sufficient information to make a sound legal decision. While there is scope for AI to support judges and increase efficiency in certain regards, I'm not convinced that substituting machines for humans would improve the quality of the decisions, nor would it replicate the features of the process which are so important for its integrity. In my view, there are aspects of the judicial function which should not be entrusted to AI. Fact-finding, the exercise of judicial discretion, and producing reasons for judgment. While the capability of AI and the public's perception of it will necessarily evolve over time, my current view is that these integral elements of the judicial function should remain the province of human minds, replete with values, creativity, life experiences, and imperfections. The imperfections is an important part of the judicial task. To a real extent, the problems associated with the judicial process, time and cost, reflect the human involvement in the process. Having identified these core features of the judicial process, which I think should remain human, I've formed the view that the use of generative AI is not necessarily inconsistent with human decision-making. In my view, AI is a prime candidate for tasks that involve identifying and collating relevant data, the acceleration of which would free up time for other work. Although there are small examples within a court system, when scaled across a large court, the cumulative effect of these efficiencies would not be insignificant. There is potential for AI to assist in the realm of case management, including effective triage and allocation of cases. Inside courtrooms, both physical and virtual, AI can facilitate faster and cheaper transcription services. AI can reduce the instances of court staff being unnecessarily exposed to distressing material. This is a potential benefit which is currently being explored in the AI pilot program in the Coroner's Court. There is scope for AI to be utilised to facilitate increased access to justice, for example, to provide swift, clear information to court users, including self-represented litigants, in relation to process. It can also assist with communicating the law and outcome of cases with the public by producing succinct, clear summaries of cases as soon as they are handed down. I also see the potential for AI to be deployed to assist with low-value, high-volume claims in certain areas at some point in the future, which might reduce delays and costs, and which would be proportionate to the issues involved. I note that the Singaporean judiciary have been collaborating with Harvey AI to explore the use of AI in the small claims tribunal, including the assistance it provides to self-represented litigants. The challenge in front of us is not to reject AI, but to discern what is appropriate augmentation and what is tantamount to substitution. There are a number of potential approaches to AI, some of which might be informed by the existential threats. It is possible, perhaps, to prohibit the use of AI altogether in courts. It's possible, perhaps, that courts should disclose its use, or alternatively, trust judges to use it in a manner consistent with the judicial method and subject to identified principles. Last month, the Honourable Justice Zhu, a judge of the General Division of the High Court of Singapore, observed that the aim is not to replace the submitted materials and to depart from the adversarial process, but to better enable the judges to recall and digest information, pursue lines of questioning, and examining the coherence and strength of what has been put before them. When and if we adopt AI in the court system, it will be important that the use of AI does not endanger trust, that the community armed with the knowledge of what generative AI can do will not simply assume that judges who use AI will use it to decide cases and produce reasons. This will require the courts to be open about the use of AI and will be aided by the publication of guidelines, preferably on a national basis. We should focus our attention on issues in our courts and tribunals that AI can ameliorate and solve consistently with the judicial process. We must explore, interrogate and collaborate across courts and jurisdictions and with the technology itself. Certainly, we must be mindful of the risks and challenges AI poses and the features of the system that must be retained by the judicial officers themselves, but not to the extent that we miss out on harnessing the positive potential in the right contexts. To that end, the courts must understand the AI environment better than we now do. We must be open to trial new technology to ensure that its use is consistent with the values that underpin the system. This will involve both investment and collaboration across our courts and tribunals in Victoria and across Australia, and partnerships with universities and research institutions. AI is an evolving tool. Human minds created it, and I am optimistic that human minds can also harness it and take full advantage of its potential in appropriate ways in Victorian courts and tribunals. We must, of course, be vigilant and ensure that AI is only employed in ways which serve the best interests of the public and do not undermine trust and confidence in the judicial system, but I'm confident that we'll be able to find a path through that challenge. Thank you.